I am sincerely humbled by this opportunity, and I appreciate the opportunity to share in this wonderful and well-deserved celebration. The number of people, both present and absent, who are worthy of acknowledgement is vast. And unfortunately, in the time allotted to me, I will not be able to list everyone. However, I would be remiss if I did not begin by acknowledging and thanking Sylvia L. Thomas, Chief Counsel of the Family Stability and Preservation Project, for her tireless efforts on behalf of New Jersey families and for this kind invitation. In New Jersey, many are the stakeholders who have dedicated their lives to the welfare of children. Children and families. And though, as I mentioned, I can't name them all, we're familiar with the organizations, individuals who comprise our impressive New Jersey child welfare system. I therefore first acknowledge the children and families who have to navigate our child welfare system, the legal services of New Jersey, the Division of Child Protection and Permanency, the attorneys of the Office of Parental Representation, the Deputy Attorneys General, the law guardians, private attorneys, division caseworkers, law guardian and OPR investigators, CASA workers, social workers, therapists, the Child Placement Review Board members, extended family members, resource families, all my brother and sister judges who serve in this area, and any others I just failed to mention. Oh, I feel sorry for the interpreter. Sorry about that. It is with deep appreciation that I acknowledge and thank all of you for your dedication and service to the most important litigants who will ever walk into our courtrooms, the children and parents of New Jersey who for a moment in time found themselves in desperate need of help. Help to overcome circumstances that for the grace of a higher power we ourselves might have had to endure. Help that our families not only require, but are legally entitled to. 32 years ago, I became a lawyer. 13 years ago, a Superior Court judge. 14 of those 16 I have spent in the family division. Over the last decade and a half, I've been afforded the opportunity to observe all of the aforementioned participants in our children in court docket labor tirelessly to protect children and to keep families together. Statistics tell us that most often the result of those labors is the inexpressible joy of a family stabilized or reunified. Yet there are times when the result of our labors is the deep regret of being unable to achieve that desired outcome. But always we labor with great passion. And the reason is clear. It is because there is no more important work to be done in our court system. Parents face terrible and daunting obstacles to reunification with their children. Obstacles such as domestic abuse, substance misuse, home insecurity, financial insecurity, mental illness, incarceration, race and ethnic disparate treatment, PTSD from abuse they themselves have suffered, and any combination of the foregoing. I read the biographies of our honorees as you did. I was both saddened, yet I was also uplifted. Saddened by all they had to endure in their lives, uplifted by their hard-earned triumphs. And when I wrote hard-earned in this speech, I said that does not begin to describe all that our honorees overcame. You are amazing, and you should be proud. Please, a round of applause for our honorees. I can't believe you mentioned my singing voice. There's a joke here, you kind of preempted. Around this time each year, I'm asked to sing at our Military Appreciation Day service. There will be no singing today, no matter who asks. Inevitably, while listening to the stirring speeches and the moving remarks, I am always constrained to consider the courage, the bravery, the sheer strength of will that allows one to place oneself in harm's way to protect all of us here back home. I often wonder whether I would have what it takes to take arms in defense of country at peril to one's own life. But You forgot to tell him I'm kind of emotional. But similarly, I am always moved, often to tears, and there's a DAG that can attest to it, during many children in court proceedings where a different but equally impressive courage is on display. In these proceedings, I have the privilege of ordering a child reunified with a parent who came face to face with what had to be their most inconceivable horror, the removal of their child from their custody. But that mom, that dad, as bravely as any combat vet, fought. And now the most precious treasure in their universe is back in their home again. I am humbled by your courage, and I know I don't possess that level of courage, strength, or fortitude. In 2021, there were 1,577 removals here in New Jersey. There were 1,015 reunifications. So now we're going to move on to the theme of today that was given to me by the chief counsel. So you don't have a whole lot of me left to deal with. Imagine a world, if you would, where reunifications aren't as necessary. As Chief Counsel Thomas wrote in a letter she shared with me, where the increased capacity to provide rapid, comprehensive responses in the areas of housing, substance dependency, mental health treatment, incarceration, and other areas could be utilized to stabilize families before a child's safety requires that trauma of removal. I have the honor of chairing the Youth, Family, and Community Voice Subcommittee of the statewide Children in Court Improvement Committee, and a more dedicated and committed group of multi-organizational stakeholders I have yet to meet. Aware of the aggregate wealth of knowledge the subcommittee possesses, I asked if they would share their thoughts on what services, what aid and support could be provided to families to avoid removals in the first place, or at least which might be emphasized. I have 16 years on the bench, but that committee has about several hundred years of aggregate training, expertise, and boots-on-the-ground experience that I knew would provide useful insights. And not surprisingly, there was significant consensus on what we could and should improve upon. And I say improve upon because here in New Jersey, we stakeholders cannot and we will not be satisfied until we are doing everything possible to improve family outcomes. I'm just going to take a short step back. New Jersey Statutes Annotated 30, 4C-11.1 requires the Division of Child Protection and Permanency to make reasonable efforts prior to placement to preserve the family in order to prevent the need for removing the child from the home. There are statutory exemptions to that mandate, but the guiding principle is clear. Remove children only when their safety and health cannot be secured by other means. NJSA 9:6B-4 is the Child Placement Bill of Rights. This statute mandates that a child be placed outside his or her home shall have a number of specific rights, among them the right to placement outside his or her own home only after the applicable department has made every reasonable effort, including, listen to these, including the provision or arrangement of financial or other assistance and services as necessary to enable the child to remain in his or her home. The statutes that I just quoted from are emblazoned on a judge's bench card that has been printed for all of us, and I am sure it rests in full view of every judge who sits in this area. Additionally, since being appointed to the Youth, Family, and Community Voice Subcommittee, I have become aware of just how extensive is the work of the statewide committee. Together with myriad specifically focused subcommittees, this organization is revamping the approach to child welfare cases. This, I believe, is attributable in great part to the vision of Chief Justice Rabner and the Administrative Office of the Court's Acting Director, Judge Grant. In every area of New Jersey jurisprudence, Justice Rabner and Judge Grant have labored to ensure the entire system is equitable for all litigants. Just a couple of the many examples. In the criminal division, by utilizing a data-driven analysis, it became unrebuttably clear that our bail system was unfair to persons with limited economic means, and an even deeper dive into that data revealed the bail system also disproportionately disadvantaged people of color. So they changed it. A bail system that had been in place for countless decades was reformed to no longer allow for a defendant innocent until proven guilty, to languish in jail waiting for their day in court because they did not possess the economic wherewithal to post bail, sometimes even pleading guilty to lesser charges that they knew they weren't guilty of to escape months or years behind bars waiting for trial. Here, in the Children in Court Division, Justice Rabner and Judge Grant have mandated trainings related to almost every point where a family might come into contact with the child welfare system. This is an effort to improve outcomes for our involved families. Additionally, they have mandated race equity trainings, as data has also revealed that removals are disproportionate with regard to children of color. Now, let me be absolutely clear. This is not our intent. Judges are not trying to do this. The Division of Child Protection and Permanency do not endeavor to remove children. Nobody wakes up in the morning saying, let me go rip a child out of their home. By law, it is a last resort. And the very existence of the statewide committee on improvement is recognition of the fact that although the New Jersey child welfare system is considered a model to other states, there is always room for improvement. We can and must always strive to do more because our New Jersey families deserve no less. The Youth, Family, and Community Voice Subcommittee offers these thoughts with regard to services which might, with greater focus, reduce removals. Parent input. Individualized safety plans require really listening to what parents believe they need and what solutions parents may have to what they need. An honest dialogue in this regard will aid in providing specifically tailored services. Who knows what parents are suffering more than the parents who are suffering? I received an email from a Morris Vicinage DCF worker, and I was excited to learn that this model is already in place. The family team model currently used shifts the parent division dynamic to one of collaboration as compared with an authoritative one. And then, once consensus is achieved, a plan is developed and implemented, and thereafter, and I love this part, to celebrate positive changes rather than just measure compliance. Next, the early assignment of counsel. A data-driven analysis brought to my attention by someone out here has revealed that access to counsel at the earliest point possible leads to fewer removals. I don't think we needed a pilot plan to tell us this, but Iowa did such a program. Iowa boasts that they have prevented hundreds of removals by ensuring parents' early access to attorneys. And I don't believe this. How can we not understand this? Viscerally, it just makes sense. Provide the parents with an attorney early in the process to help navigate our, to some degree, difficult child welfare system, and family outcomes will improve. I read a book recently, it's entitled Think Again, and after reading it, I was even more appreciative of the data-driven approach to problem solving in our judiciary. This book is replete with examples of how stubborn commitment to an initial premise often results in failure. In a data-driven, and I'm quoting from the book here, in a data-driven scientific mode, we refuse to let our ideas become ideologies. We don't preach from intuition, we teach from evidence, close quote. That is why the Children in Court Improvement Committee is comprised of stakeholders from every organization and charged with making the necessary changes that the data reveals are necessary. Only got 3 pages left. What else can we do to prevent removals? I'm going to go back to the judge's bench card. Identifying family problems, arranging and funding culturally appropriate quality services to help the family stay together, assessing extended family and friends as supports to the family, developing safety protection plans with parents or caregivers to keep the child at home, and providing services such as family therapy, parenting classes, drug and alcohol treatment, respite care, parent support groups, home visitation programs, child care services, homemaker services, counseling, individual, group, and family, health care services, mental health and behavioral evaluations and treatment with culturally sensitive providers, transportation, anger management, treatment, domestic violence services, housing advocacy, and financial help, language access, and referrals to and help in navigating social service agencies. The last one, finally, a recognition that poverty is not neglect. If it were, my parents would never have made it from 1930s Birmingham, Alabama, to Mendham, New Jersey, with our family intact. We was po'. In her keynote speech at the 2015 Reunification Day celebration, I heard then Assistant Commissioner of the Division of Child Protection and Permanency, Lisa Von Peer, speak about the importance of keeping children in the home. Keeping them in the home while families utilize the specifically tailored services provided to work on achieving their successes. And some of the services that the assistant commissioner listed then included helping families secure housing vouchers, the provision of funds to pay back utilities, back rent, and for down payment for apartment rentals. Why such a forward-thinking approach? An approach that I know that this current director embraces, as I've heard her speak. Why such an approach? It's because poverty does not equal neglect. Perhaps with greater focus on preventive and stabilizing supports, New Jersey child welfare can be even better than we know it to be. Unifying more and more families before reunifying families even becomes necessary. I have taken enough of your time, and it would have been a lot longer had I not thrown it into like 78 mode and read this thing as quickly as I possibly could. I have the privilege to participate on the aforementioned improvement committees, and I am honored to be a part of a child welfare system that is not interested in proving that our way is the right way, but rather improving each and every facet of our system. As was told to you, I am the first and only African American judge in Morris and Sussex counties. My life journey has been interesting, but I can tell you with indisputable and unassailable certainty that every tragedy endured, every obstacle overcome, every success achieved is directly attributable to 2 things: God and the unwavering, the heroic support of my family. A mother and a sister in particular, gone now, provided 4 decades of extraordinary and specifically tailored services to help remediate my many shortcomings. Nelson Mandela said, "There can be no keener revelation of a society's soul than the way in which it treats its children." And from what I've seen a lot in 32 years. 32 years in the law. I wish I was 32. I am persuaded that children do best when allowed to rest in the love, nurture, and support of a safe and caring family. Our job, our legal obligation, our moral obligation is to do everything maybe unreasonably possible to help New Jersey parents maintain a safe and nurturing home environment no matter what dire circumstances life throws their way. I challenge anyone here, any of us, to have been able to overcome what our honorees were able to overcome without a great deal of support and help. Yet somehow they succeeded through their own strength and determination and the provision of a helping hand. I ask each of us today to recommit to making reunifications less necessary by making removals the last resort. I thank you all.